and will be available in the next few days on the library's YouTube page. I will put a link to the library's website in the chat. You can access the YouTube page as well as our calendar of events from that link.
Grand jurors in the Eastern District of Virginia, that there was
Well, give me just one second. Okay. You can also check out our website calendar for upcoming events. We're so glad to have Adam and David with us here tonight. Adam Liptak covers the Supreme Court for the New York Times. A graduate of Yale College and Yale Law School, he practiced law for 14 years before joining the Times' news staff in 2002. In 2007, he began writing Sidebar, a column on legal affairs. In 2008, he became the paper's Supreme Court correspondent. Liptak was a finalist for the Pulitzer Prize in Explanatory Reporting in 2009. He is a member of the American Academy of Arts and Sciences. He has also taught courses on the Supreme Court and First Amendment at the University of Chicago Law School, New York University School of Law, and the Yale School of Law. David Rudenstine is the Sheldon H. Solo Professor of Law at the Benjamin N. Cardozo Law School and a former dean of the law school. He has taught constitutional law for over 4 decades. He is the author of The Day the Presses Stopped, A History of the Pentagon Papers Case and the Age of Deference, the Supreme Court, National Security, and the Constitutional Order. David is also the author of a forthcoming book on Chief Justice Charles Evan Hughes, published by the Harvard University Press. We're so grateful to Adam and David for generously sharing their time and expertise with us this evening. If you'd like to support the library's mission to provide diverse programming to patrons of all ages, you can make a donation through the link that I will post in the chat. Thanks again for being here, Adam and David.
Okay, thank you, Meg. And I just want to say that the Hunt Library in Falls Village is a terrific institution of great importance to all the kids in the community at large. And Meg has done a great job as a director. I also want to thank Adam for putting aside his time for being here. And apart from what Meg just said, I want to just add a moment. Adam, as I understand it, you were a copy boy at the New York Times in 1984?
Yeah, between college and law school, I had the lowest level position of fetching coffee and walking wire copy around. This was long enough ago, pre-computers, the wire service materials would come out in quintuplicate, and I'd walk it to the national desk and the foreign desk and so on. That was
so maybe why don't you quickly tell us how you, where your aspirations came from in order to go from where you were as a copy boy to where you are?
Well, I always wanted to be a journalist. I did it kind of badly. I was on my school paper at Yale. That led to that menial position at the Times, which many, many people rose up from, were noticed by superiors, and were made into junior reporters and real reporters and went on to lead the paper and so on. Nobody noticed me, so I went to law school in the back of my head thinking I would get back into journalism somehow. And it took a while. I worked for 4 years at a Wall Street firm called Cahill, Gordon and Reindel, which was notable for being Floyd Abrams' law firm, the great First Amendment lawyer. And then a job opened up at the New York Times, but not in the newsroom, in the corporate legal department. And I worked there as a libel lawyer for another 10 years. And then I continued to do a little bit of writing on the side, and just enough that the editor of the Times, Howell Raines, noticed me and had the insane idea of let's get the guy from the legal department to come down and be the national legal reporter, covering the law generally from New York. And that was terrifying because I really didn't have the skills. I didn't have any sources. I didn't really know how to interview people. I didn't know how to write fast. But after about 6 months of terror, it worked out, and it helped some that I had the legal training. And then over time, I started the column, as Meg mentioned, almost 2 decades ago. And then in 2008, much to my dismay, Linda Greenhouse, my great predecessor, who had covered the court for 30 years, decided to retire. And I was afraid that they would offer me the job. And I didn't want to follow Linda. I didn't want to move to Washington. I didn't especially want to cover the court because in the old beat, covering the law generally, I got to pick my shots and write about things other people weren't writing about, to shed light on legal issues and injustice. And moving to Washington and covering the court meant that 9 people in robes would choose the stories I wrote. And I would be competing against a very strong press corps. And most of us write the same stories every day. So I tried as best I could to talk myself out of it when they offered the job to me. But it was hard to turn down. I mean, by some measures, the best job in American legal journalism. And I've done it. I did it for 17 years. I'm about to transition into a slightly different role. And it has been, as Robert Bork famously said, an intellectual feast. We'll talk about this, but the court has changed a bunch, most notably from being a kind of weak 5-4 court with Justice Kennedy in the middle, where both sides would win some, lose some, to this 6-3 juggernaut dominated by the 6 Republican appointees.
Well, you've been the correspondent since 2008, and let me just quickly say that on behalf of all of us who are in the country, we want to thank you for keeping us apprised and informed about what's going on in the Marble Palace. So, look, we're focusing here on John Roberts, right, who is now he just completed 20 years as the Chief Justice. Only 3 prior Chief Justices served that long. Marshall the fourth, Tawney the fifth, and then Melvin Fuller, who was on the court from, I think, 1888 to 1910, I think. Nobody else has done 20 years. Rehnquist came close at 19.
There's a whole article.
But nobody else did more than that. And you've been watching him since 2008. So why don't you tell us a little bit about his background before we dig into the substance of what he and his colleagues have been doing?
Well, his history major at Harvard College, graduated in 3 years, goes to Harvard Law School, clerks for the great Circuit Court Judge, Judge Friendly, clerks for William Rehnquist, then Associate Justice, and has jobs in the Reagan White House, works in the Solicitor General's office, is the principal deputy, and in private practice is maybe the most accomplished Supreme Court litigator of his day. Sort of, I don't know if the name Paul Clement means anything to you. He's probably the greatest Supreme Court advocate today. John Roberts was that. And when Sandra Day O'Connor decided to step down, President George W. Bush decides to appoint John Roberts to that slot to be Associate Justice John Roberts. But soon thereafter, his former boss, now Chief Justice Rehnquist, dies, and Bush moves him over to the Chief Justice slot. So a kind of happenstance there gives him enormous power. And at the age of 50, he comes onto the court, I think 50, and is the youngest person at the court, but now is also the nominal leader. You can't call him the boss of the other justices. Everyone gets 1 vote. But he has a lot of power. He assigns the majority opinions when he's in the majority. He leads the discussion at conference. He does a lot of administrative stuff. And he seems at first to be a standard issue Republican operative. And I think had he been Associate Justice Roberts, as he almost was, he would have been a very reliable vote on the conservative side. But as Chief Justice, at least initially, he understood himself to be the custodian of the court's legitimacy, authority, and prestige. And he would not often, but in important cases, sometimes surprise us, notably by voting to uphold the Affordable Care Act, Obamacare, in 2012. And you sort of had the sense that he was, in the scheme of things, a moderating force. That was not, at all the only way to think about him. He was in the majority in Shelby County. He was in the on striking down the Heart of the Voting Rights Act. He was in the majority in Heller, revolutionizing the Second Amendment to guarantee an individual right to bear arms. He was in the majority uh, in Citizens United, amplifying the role of money in politics. But nonetheless, he would occasionally surprise us. And then I think in the last couple of years, and most notably in the immunity case that gave then candidate Trump, then former President Trump, enormous leeway in really creating a kind of vision of the presidency that gives the president almost unbridled power. And now, in a series of upwards of 20 emergency orders, greenlighting these very ambitious Trump initiatives, we seem to have a different version of him. So he's a work in progress.
Right. So let me just break that down a little bit because he is on the court for 20 years now. And as you suggested in the beginning, he was one vote above about with nine, but he might have been in many important respects a possible swing vote between the conservative four and the liberal four. And that dynamic, I think, more or less lasted until there was the first change, which was Justice Scalia dies and Gorsuch takes his place. That doesn't change the balance in the voting. But when Kennedy steps down and Kavanaugh comes on, Kennedy was at times voted with the liberal bloc. If you think about same-sex marriage, for example, that would be his critical vote. It's not at all clear where Justice Kavanaugh thinks about that. So when that happened, there was Roberts was still important, but not maybe quite as important. And then when Ginsburg dies and Barrett comes on, he now is basically the sixth conservative vote on the court and is no longer the swing vote at all. And so,
And that's powerfully, sorry to interrupt, David, but that's powerfully demonstrated in the Dobbs case, the abortion case that overruled Roe v. Wade, where the five justices to Roberts's right overruled Roe as such. And Roberts votes to uphold a Mississippi law that severely restricted abortion, but he was not willing to go all the way to strike down Roe. And it was, and that illustrates that he doesn't have control of the court. He's outflanked on the right, and he's put to this terrible choice I have to think in his mind, of do I want to be dissenting with the three liberals and getting nothing done? Or do I want to be with the majority where I can assign myself the majority opinion and maybe moderate it to an extent?
Right. Before we get to the emergency docket, which I want to get to, but I want just unpackage for a moment his authority for assigning opinions, because that can be very, very important. So he writes the opinion in the Trump immunity case, but Alito writes the opinion in Dobbs. So explain to folks how that happens.
If the senior justice in the majority gets to assign the majority opinion, the Chief Justice is senior to everybody else, however long he's been on the court, whatever his age is. So that means, as a practical matter, that the Chief Justice assigns almost all the opinions, because Roberts is in the majority 93% of the time. And that gives him enormous power. First of all, to keep the big decisions for himself, as he will often do. Second of all, giving the decision to someone he thinks will do his bidding. And that could be to make the decision aggressive. It could be to make the decision moderate. So that assignment power is quite significant.
Right. So Justice Alito ended up writing the majority in Dobbs. I take it Justice Thomas gave him that opinion.
That's perfectly logical. That's almost surely what happened. I mean, this is the subject of discussion among Supreme Court nerds. Given that the chief was in the majority about the judgment, the outcome of the vote on the Mississippi statute, Could he have tried to keep it for himself? He could have, but it would have been pointless because he would have lost his majority. So either Thomas assigned it to Alito, or conceivably the chief assigned it to Alito.
Right. Okay. So with all of that introduction, why don't we shift over to what may popularly known as the shadow docket. Docket is no longer in the shadows. It's on the front pages on a regular basis, and there was quite a lot of it this summer. You mentioned it, but you used the term the emergency appeal. So why don't you explain to folks what this is and why it's so unusual, and why it's been so contentious for the court to be deciding so many important issues this way?
So the best way to think about it is to think about the usual Supreme Court case, what we're used to thinking about, what I'm used to writing about. That's an elaborate process that gives rise to a very careful, well-reasoned opinion. It starts with a party going to the court and saying, please hear my case, filing a so-called petition for certiorari, a petition seeking review. The court will mull that and grant maybe 1 out of 100 of those petitions. If it does, it will order a second round of briefing. It will get a lot of friend of the court briefs. It'll hear oral arguments. The justices will meet in private and vote, and then the majority opinion will be assigned. Drafts of it will go out. Uh, People will make comments, will dissent, will concur. And after this whole process unwinds itself, it takes about a year. We'll get an opinion that's sometimes 100 pages or more that gives all kinds of reasons and gives guidance to litigants, judges, citizens about what the law is. That's the merits docket. That's the usual process. Separately, sometimes cases reach the court on emergency applications. Those are very thin briefs that ask the court to act very quickly. They're accountable to the public, and they face election. The judicial branch claims legitimacy by dint of reason, by dint of explaining itself and expounding on what the law is and letting you engage with it. And in lacking that feature, these emergency orders are to a lot of people, troubling and even lawless. And we have seen in the first 8 months of the Trump administration 25 emergency applications. The court has ruled on maybe 20 of them. All the administration is won 85% of the time, depending on how you count. And so we have a situation where we have a very aggressive president who's being checked by lower courts, but the Supreme Court is overriding those lower courts and letting the administration's programs go into effect.
Yeah. Why don't we give, if we could, one or two examples of cases that were decided this way, two that come to my mind, and see if there are things that you can talk about. One is the Department of Education case, and the other is the Los Angeles immigration case. I think it's Vasquez versus Perdomo, right? Do you or you
Yeah,
could talk
sure.
about another one, but to give folks an idea about exactly how much of a policy crisis is involved here in the court making a decision without full briefing. So maybe you can
And,
just unpackage
right.
one. Yeah.
Um, so the Department of Education case was one of a handful where the Trump administration wants to shrink the size of the government and do away with agencies it doesn't care for. And it announces that it's going to fire about half of the Department of Education's employees. Labor unions go to court, individuals go to court. Lower courts say you can't do that. You're acting too fast. You don't have authorization for it. Congress created this agency. Congress has to uncreate it. And without anything like elaborate reasoning, the court lets it go forward. suggesting that while President Trump has talked about eliminating the Department of Education, what's going on here is not quite that. It's just firing a lot of people, and in that setting, and also in an important set of cases, not on line employees, but on the leaders of independent agencies. The court seems poised to say the president runs the executive branch, he can do what he wants, and Congress can't control him. Congress can't say you need a good reason to fire somebody. The immigration stop case comes out of LA, where ICE was like literally dragging people off the street on basically no evidence aside from perhaps that the person looked Hispanic. Civil rights groups go to court. The trial judge says the Fourth Amendment gives people, including non-citizens, rights. And the trial judge says you can enforce the immigration laws, but you can't stop and detain people for the following four reasons, alone or in combination: that you appear to be ethnically Hispanic, that you speak Spanish or accented English, that you're at a workplace of a kind, Home Depot or something similar that sometimes unauthorized immigrants gather at, or that you're engaged in a certain kind of work like landscaping.
Yeah.
And the Ninth Circuit upholds that order, and the Supreme Court, without a word of reasoning, strikes it down, and the stops continue. Because there's no reasoning, and this has been a pervasive problem in a lot of these orders, lower courts don't know what to do. I guess we know in California that those limitations are not in place, but the administration says California is a special case, or the LA area is a special case because they claim that 10% of the people there are unauthorized. We don't know how that works in Chicago or in Memphis. The lack of reasoning has given rise to a lot of confusion, and there's this back and forth between the Supreme Court and trial judges these days, where trial judges are saying, are these precedents? There's no reasoning. We can't tell what we're supposed to do. We'll do our level best to interpret them. And a few weeks ago, Justice Gorsuch wrote a kind of nastygram to federal judges saying, you're defying us. And he singles out three judges in particular cases. Those judges did not enjoy the experience. They were doing their level best to interpret these unreasoned opinions. And so this is unhealthy in many, many ways, but including within the federal judicial system.
You said, and this struck me, that 85%, I think, of the emergency orders in calendar year 2025, 85% in those cases, President Trump's administration prevailed. So against that, Bari Weiss conducted an interview with Justice Barrett about her new book at Lincoln Center a couple weeks ago. And Justice Barrett said in one of the statements that the court decides cases not with regard to a particular president, but with regard to the presidency altogether. So I'm just wondering how this 85% figure lines up against that. Is it credible? Do you have a sense from, what do you think about that?
So I did a little data research, and it's not apples to apples. They're not in identical cases. But the Biden administration went to the court over 4 years in about 18 emergency applications, and it won 53% of them. Much greater volume, much shorter time. The Trump administration is winning 30 percentage points higher. So draw from that conclusion what you will. Another thing to note is the justices really claim that politics does not affect their judging. But if you look at the individual votes in these cases, comparing the Biden administration to the Trump administration, Justice Alito uh, voted for the Trump administration 77 percentage points more often than for the Biden administration. Justice Alito, perhaps the most conservative justice. The two most liberal justices, Justices Sotomayor and Jackson, voted in favor of the Biden administration 77 points higher than for the Trump administration. So whatever can be said on the merits docket, and on the merits docket, they're often unanimous, maybe 40% of the time. They're fairly seldom breaking 6-3, maybe 10% of the time, because there they can deliberate and try to persuade each other and narrow the cases and find consensus. None of that happens in the emergency docket. So among the many problems with it is that it exacerbates partisan polarization.
Okay, so, all right, let's switch over if we can from the shadow docket or emergency docket to, let's say, a line of cases that fit under the big umbrella of the unitary executive. And so what I was thinking that was maybe you could unpackage that idea a little bit. Tell us a little bit about where it gets off the ground in contemporary times, and why, it seems to be mainly advanced by conservatives as opposed to liberals. And why is that? And then let's turn to some of the cases. I think I identified three areas that we could talk about. One would be presidential immunity. The other is administrative agencies losing their jobs. And then the third is the Lisa Cook on
Yeah.
the Federal Reserve power. And then I guess also I could add impoundment, which comes up in the Department of Education case that you already mentioned. So
Yeah.
why don't you go back to the beginning on unitary executive and then open it up here?
So the unitary executive theory, which is not insane, uh, really arises in the Reagan years and is uh, an understanding of presidential power as being quite broad and certainly within the executive branch. So the idea is that the president runs the executive branch, and at least in that setting, he can do what he likes, say what he likes, fire whom he likes. And this arises in various settings, but maybe most pointedly in the context of independent agencies, which may be something the Constitution didn't contemplate. It's the idea that Congress can create the FCC, the Fed, the NLRB, lots and lots of agencies, and insulate their leaders from political pressure. And it does that by saying, yes, the president appoints, Senate confirms, but the president may not fire except for good reason. And that concept offends fans of presidential power who say the president should have the authority to run the executive branch. And there's been litigation over the years, uh, notably when FDR tried to fire uh, a member of the FTC in a case called Humphrey's Executor. And the court said, no, the congressional restrictions are okay. And we lived in that era for the longest time. Uh, but the Roberts Court started to chip away at this idea, first by saying that we're not going to tell you about multi-member boards, but if you have the head of an agency who's the sole head of the agency, the president needs to be able to fire that person. And then lately, we've had a raft of these cases as Trump is firing people without cause. And the Supreme Court has green-lighted two of them, is about to green-light a third in a case involving the FTC. And even as it does that, it says the Fed is a special case. The ability of a body to set monetary policy independent of and insulated from political pressure is important. And we're putting the Fed in a separate category. And the Trump administration seems to buy that so far, because although it talked about firing the chairman, Jerome Powell, it didn't do that. And while it's trying to fire Lisa Cook, it's not claiming they can fire her with no reason. It's claiming they can fire her for what may be a concocted reason, but for cause. And there's an emergency application on that pending now. The opposition brief just came in this afternoon. Uh, it features not only Abby Lowell, who defended Lisa Cook, but also now Paul Clement. Uh, an incredible amicus brief was filed by every living former chairman of the Fed and many Treasury secretaries insisting that Fed independence is really important. And you probably remember that the cause that Lisa Cook is accused of, the cause Trump cites, is that she may have committed mortgage fraud by claiming before she took office two different residences as her primary residence. The paper trail on that is disputed, but there is enough pushback on this that I think at least the court is not going to do anything on an emergency basis, I think, although they may set it down for argument on the merits.
Right.
You had 3 points, David. I think I probably only talked about one of them.
Well, let me come back for a moment, just so that we get this clarified. Administrative agencies of the kind that you just mentioned, the FTC, the NLRB, it's likely that Humphrey's executor, which has protected them in the past, is very likely that that's going to be overruled. That seems to be the signal, right?
That's going to happen this term, yes.
Yeah. So then the distinguishing factor is whether or not the Federal Reserve Board will be treated differently. And for the Reserve Board was founded in 1913, so it's been around for a little bit more than a century. And the officers, I think, have been protected all of that time. And so, as you say, the argument is that that should be treated differently than the agencies. And so, even if the court sees its way to overrule Humphrey, it should respect the independence of the Reserve Board, right? So, all right, put that aside. What about presidential immunity? This is a Roberts opinion, right? So let me focus it this way. As I understand the opinion, if you have core executive power, core presidential power, then no matter what you do in discharging that power, you are immune from criminal prosecution. So here's the hypothetical. The president's power to pardon, as I understand it, is absolute, no qualifications. So Donald Trump, who seems to be capable of saying almost anything to anybody under any circumstances, basically says, if you're convicted and serving time, you give me $1 million, I'll pardon you. There's a real quid pro quo there. There's hardly anyone who's going to doubt the fact that we have here an obvious statement of a bribe. But as I understand the immunity case, he cannot be prosecuted for that. Am I understanding that correct, or am I off base on this one?
No, that's my understanding also. And there were hypotheticals at the oral argument about whether he can order SEAL Team 6 to assassinate a political opponent under his commander-in-chief power. And his lawyers said, he'd never do that. He'd never blow up a Venezuelan boat. Um, but the court seemed to go along with that. There was a little back and forth in the opinion between the Chief Justice and Justice Barrett about the bribery example you posit, David. And the whole opinion was a Roberts product, which ordinarily means it's at least tightly reasoned. This was not an example of that. But Roberts didn't seem to go all the way toward you might never be able to prosecute him for bribery. But he did say you couldn't put in evidence of what his official act was. And if that doesn't make sense to you, that makes two of us. But this subject was ventilated a bit, but not resolved in the opinion. But the basic point, as you say, David, is that core presidential power is immune from judicial or other scrutiny. The only way to come after the president, the court said, is impeachment. And a historical example might tell you just how radical that thought is. Many of you probably remember that the tipping point in Watergate was the revelation that Nixon had instructed the CIA to tell the FBI to back off because this was national security business. And that was enough for Nixon to fear impeachment and resign. It turns out he had nothing to be afraid of because he would be immune from that.
Right. All right, I could actually ask you more questions about that, but we're going to run out of time, and I want to get to originalism if we could, and on that score, Heller and Bruen and abortion, affirmative action. So, uh, again, if you could historically give us an idea about the contemporary origins of originalism with Bork and Scalia, I guess, and putting aside what scholars say about originalism, tell us what the justices say about originalism in this public meeting, and then let's give some examples with Heller and Bruen and maybe Rahimi, the abortion case. Okay.
Right. So this also arises basically in the Reagan administration, and it's the product of frustration with what conservatives thought was a kind of freewheeling approach in the Warren Court years to the Constitution, where they would say that judges were just imposing their own values on the public and making up rights. And in an effort to constrain judges, they came up with this idea that you have to follow what they first said was the original intent of the framers, and later shifted away from intent to the original public meaning of the Constitution when it was adopted. And that does not sound crazy by itself. The Constitution is a legal document, and you may want to try to figure out what people meant it to achieve, but it's not a lease or a will or a contract. It's a constitution that's meant to, many people would say, be open textured enough to take account of changing circumstances. And people, mostly on the left, would say that a constitution is a living document that should keep pace with the times. I don't think that originalism actually yields predictable results because you can operate at varying levels of generality and come up with different answers in different settings. Uh, so, by way of example, in the Heller case in 2008, the court overturned what had been the longstanding understanding of the Second Amendment, that it protects a right to bear arms tied to militia service. And the structure of the Second Amendment is more or less that a well-regulated militia being important to the nation, first clause, the right of the people to keep and bear arms shall not be abridged. I'm paraphrasing, but the relationship between those two clauses matters, and the first clause about militia service might well be understood to modify the second clause about the right to keep and bear arms. In the Heller decision, both sides, Justice Scalia writing for the majority, Justice Stevens writing for the dissent, draw upon historical materials to figure out the status of contemporary gun control laws. Now, you might think that, among other things, you might take account of crime rates, different kinds of weapons, contemporary reality. But both sides are like delving in the historical materials. And 5-4, the Supreme Court says that the Second Amendment does protect at least an individual right to keep arms in the home for self-defense. That's expanded in Bruen to protect carrying guns outside the home for self-defense. And then the court fairly quickly runs into the problem of, a real life setting where some of this starts to be absurd, where someone subject to a domestic violence abuse order is prosecuted under a federal law that says if you are in that setting, you can't have a gun. And now the Chief Justice writing for the majority says, well, wait a second. We think in the founding generation, although there was no such thing at the time as a domestic violence abuse order, we think they would have probably thought that, and it kind of demonstrated uh, the incoherence of originalism, many people would say.
Right. What about abortion? You have Justice Alito's opinion that goes on forever and ever and ever. In some respects, he basically argues that in order to find an abortion right, you have to go back to the 14th century and then go forward. But in other aspects of the opinion is more limited to what the original public meaning was, right? Um,
Yes, and also I think he did and should have not so much looked at ancient history, but looked at the provision of the Constitution that Roe relied on, the 14th Amendment, which is not, from the 1700s, it's from 1868. And people, both sides kind of counted up laws. But one thing about originalism, and you see this in the guns cases in particular, uh, Scalia contends that the absence of gun regulations in the founding era meant that gun regulations are not appropriate, not proper. But just because the community chose not to enact such regulations, such limitations, doesn't mean they thought they were powerless to do so. They may have just thought they didn't want to because they didn't have a problem. But the absence of regulation doesn't prove that the people at the time thought they were powerless to regulate.
yeah. And what do you think about the court's selective utility or useful implementation of originalism? So, I mean, in obvious cases like the immunity case, they don't use
There's no
originalism.
originalism in that.
And in the Colorado case where Trump's name was on the ballot, but some people wanted to kick it off, they didn't use originalism there either. And then just the other day, I got a book by Richard Phelan, who's at the Harvard Law School, called The Changing Constitution. And on page 80 or 62, he says that he and his law clerks went back to the October 22 term that ended in June of 23. And of all the cases that were decided, they found only 5 cases where originalism was used. So some people say that originalism matters when it leads to a result that the conservative members of the court want, and otherwise they put it into the dump heap. How do you think about it?
I think there's a lot of opportunism in the court's decision making. I don't think all of it is conscious or in bad faith. Um, but it, it's much easier to predict the result of a case by looking at the party of the president who appointed the justice than to look at some abstract legal theory.
Yeah. In Alito's opinion in the abortion case, finding that a woman did not have an abortion right, he goes out of his way on, I think it's page 72, to make it to make the point that the reasoning in this case has no impact whatsoever on same-sex marriage, or even the use of contraceptives. The use of contraceptives, some folks may not realize this, Connecticut banned it until 1965, and the same-sex sex decision goes back to 2003, and same-sex marriage goes to 2015. If in fact you were using the originalism methodology, all of them probably would be declared invalid. But here he is in this nationally prominent opinion telling the American people that no, we're not going to do that. How do you think about that?
I think the logic of Dobbs would cause you to strike down all of those decisions, overturn all of them. Justice Thomas, in a concurring opinion, said they should all be reexamined. I would say one thing in their defense. I don't find this particularly persuasive, but while the constitutional analysis, the logic of it would require all of those cases to be overturned, there is a different analysis under stare decisis, perhaps for some of these. Stare decisis means respect for precedent, legal Latin for to let things stand. And for same-sex marriage, for instance, I think the reliance interest of people who have been married is maybe different from the reliance interests on women who seek abortions. They're both important interests, but they're not exactly the same.
Yeah. Look, there's we could go on. We could talk about democracy and minority rights and there's a campaign financing and all of this, but we don't have many minutes left, and I want to get your views on this sort of fundamental issue that a lot of people in the wake of what the Roberts Court has been doing are asking, does the court find the law or does it actually make the law by exercising broad discretion, right? So I think most of us in the business would say finding the law is ridiculous. They obviously have broad discretion and they make the law. Um, but when you read the originalist opinions in the gun cases, especially Justice Gorsuch and Kavanaugh, they go out of their way to basically say, yes, we basically have some discretion, but I think Justice Gorsuch's words are, it keeps us in the lane, right? He suggests that the exercise of a historical analysis sharply limits judicial discretion, and that's in contradiction to what the Warren Court did, right? I guess my question in some respects is the lane, even assuming there's a lane there, is the lane broad enough to still allow different outcomes of the kind that you had, for example, in Rahimi between Thomas and the other members of the court? And if it's broad enough to allow contradictory outcomes, then is this all not just a facade?
Let me answer it this way. Um, I don't think it's an either or. I think nobody doubts that there's a substantial element of politics, particularly in the headline grabbing constitutional cases. But I don't think law has no place in the Supreme Court's judging. I think particularly in statutory cases, particularly in less significant cases, the justices do act as lawyers and try to make sense of and come up with the correct legal answer and come up with workable, pragmatic solutions to things. So it's I don't have a definitive answer, and I think the Gorsuch construct is not so terrible to acknowledge that obviously the nation's highest court, which decides cases which have divided the lower courts, where serious people on both sides have said, this is a hard issue. I'm going to come out this way. I'm going to come out that way. It reaches the Supreme Court. And they, reasonably often, unanimously, quite often by unconventional alliances or 7-2 or 8-1, come to certain conclusions. I think all of that pushes back the idea that it's only politics,
Yeah.
but that there's a lot of politics involved. No serious person and certainly no political scientist would dispute.
Yeah. So I think you're absolutely right. I think everybody who is a close observer of the court would agree that with regard to the bulk of the court's decisions, it's fairly clear that the court is not exercising what you would call unleashed or broad discretion. They're paying much more respect to the text of the statute or judicial precedents construing the Constitution, and may feel more of an obligation to comply or be consistent with that. But when you get to these cultural upheavals, these hot button issues, it's a different thing. And so when Chief Justice Roberts said back in his confirmation that he would only call balls and strikes, I take it, putting a good faith on that, is that he was talking about 90% of the docket, but not the 10% that the American people read about on the front pages.
I find it hard to disagree with you. And, in June, after the court has had a fairly sleepy term, they will unleash half a dozen cases, which these days are quite predictable and quite consequential victories, almost always by 6-3 votes, on all kinds of things, on affirmative action, on abortion, on guns, on student debt, on the administrative state. And that's not the best look for the court.
Yeah. The Supreme Court's standing in the eyes of the American public, as I understand it, is almost at an all-time low, at least during the last 50 or 60 years. Um, and I guess my assumption is that that's because the American public is in disagreement with the outcomes of cases, because most people don't read Supreme Court opinions. They'd rather read a novel or something else, and that would exercise good sense in doing so. Uh, is this, if there's any merit to that, does that tell us that Supreme Court outcomes are, in many respects, on these hot button issues, far more important than the argumentation that the court offers in justification for its decisions?
So I agree with the last point, and let me explore the premise with you a little bit. It's true that the Supreme Court's public approval ratings are testing lows. On the other hand, two things. Still far above Congress, uh, far above the presidency, far above journalists, uh, and second, deeply polarized. It used to be that the Supreme Court's approval ratings were not sharply divided depending on whether you were asking a Democrat or a Republican. So the approval ratings are about 42%, but among Democrats, now I'm going to make up these numbers, but it's like 15% approval, among Republicans, like 75% approval. So this is another instance of the nation being really wrenchingly split.
Yeah. Um, Retirements. So from a liberal point of view, you need to get quite a few seats in order for there to be perhaps a change in tilt on these high-profile cases. From the conservatives, they would want to keep a majority for as long as possible. Is there any reason to believe that Justice Thomas, who is the oldest member of the court and who's been on the court since 92, might be stepping down in order for Trump to appoint a younger person, for example?
I don't sense that Justice Thomas wants to go. In fact, I think he's enjoying his power. If someone were to go, it might be Justice Alito, who's only a few years younger. But even there, he's hired clerks. There's no rumor, there's no scuttlebutt. If he were to go, he should go soon because there's at least a chance the Democrats will take the Senate next year. But let's assume even both of them went. Um, well, it's a for there to be a Democratic majority on the Supreme Court in our lifetime, in my lifetime, it's a real a lot of things would have to happen.
Yeah, I completely agree. The way I would see it is that the older justices who are on the court, like Thomas and Alito, if they wanted to avoid the risk of Justice Ginsburg and dying in office, they might very well step down, but they may not. You haven't heard anything. So here's the last question, right? We have another term about to begin. What should we look forward to in terms of the big issues that are going to be before the court?
There's two different cases involving uh, trans people, one of them also involving gay people, on whether states can ban so-called conversion therapy, where licensed therapists try to talk people out of being trans or gay. Second, whether trans athletes can compete in women's sports. There's a real danger to the what remains of the Voting Rights Act, the possibility the court will find it unconstitutional. Um, we're going to see this question of can the president remove uh, leaders of independent agencies? There's yet another campaign finance case. I would expect birthright citizenship to reach the court, although they haven't done so yet. So probably only half the docket has been filled so far, and it's already turning out to be a fairly important term, and it'll probably turn out to be even more so. And now, David, I've just been talking about the merits docket. We will continue at the drumbeat of emergency orders too.
Yeah. Adam, thank you very much. I think we promised you and everybody else 1 hour. As I see the clock here, we're ticking down. Meg, did you want to, apart from thanking Adam, and let me figuratively say thank you, Meg, did you want to say anything in conclusion?
I just wanted to thank everybody for being here with us tonight. And thank you again, David and Adam, for giving us your time and your expertise. We appreciate it.
Real pleasure to be with you all.
Thank you very much, Adam. Okay, good night, everybody.
Thanks, everyone. Good
Bye,
night.
bye. Good night.